Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if an employee is absent due to alleged illness but on the day of absence participates in protest action. Abuse of sick leave is a common occurrence in most workplaces. Some employees are of the view that what they do whilst on sick leave is none of the employer's business. But what if an employee during a period of sick leave is witnessed participating in a protest? Does this constitute misconduct? And if so, can an employee be dismissed? On 20 July 2023, the Labour Court, in the matter between SARS versus the CCMA and others, delivered a judgment addressing this exact issue. So let's look at the facts. On 7 September 2020, the employee in question sent a text message to his supervisor to the effect that he was not feeling well. The following day, the employee informed his supervisor that he was still not feeling well. On 9 September, the employee consulted a doctor and was booked off from 9 to 11 September 2020. The nature of illness on the medical certificate stated medical condition. Whilst watching the news on television, the supervisor spotted the employee participating in a protest march, called by the EFF against clicks, on the 2 days that he has called in sick. He was seen singing as well as clapping his hands. Upon the employee's return to work, the supervisor confronted him in writing and stated to the employee that he saw him on the news while he was expecting him to be off due to illness. The employee responded to the supervisor that on the morning of 7 September he was not feeling well and that later on the day he became a bit better after taking some medication. He said that a friend came to check in on him and the employee asked the friend if he can accompany him to Sandton. The employee said that he does not see anything wrong with it because he thought maybe it is good to go out and, in his words, stretch a bit as he was not bedridden. The employee further said that the following day he got worse. The employee was charged with dishonesty, he was found guilty and was dismissed. He referred the dispute to the CCMA, where the Commissioner found his dismissal to be substantively unfair and awarded his reinstatement. SARS was not happy with this outcome, so they took the matter on review to the Labour Court. So, what did the Labour Court have to say? The court said the following. By participating in protest action, the employee was not so indisposed that he could not attend his work, and that by telling his supervisor that he was not feeling well, so that he must be excused from work, he was not being truthful about the state of his health. Had he indicated to his supervisor that he seeks to be excused from work in order to participate in a protest action, his supervisor would have not excused him. The court held that, knowing full well that if he provides the true reason for being excused from work, he will not be indulged. In all probabilities, he had to fake illness in order to achieve a justified absence. The court said that there was no objective evidence to support the allegation that on the days of the protest action, the employee was indeed not feeling well. The court said that a reasonable decision maker, applying the accepted and trite standard of proof on the balance of probabilities, would have come to the conclusion that the employee absented himself on the days in question in order to attend to the protest action and not that he was ill. Despite calling ill, the employee attended the protest action where he sang and clapped hands in support of the action. The court said that surely a person who is not feeling well cannot be expected to act in such a manner. The employee expected to get away with the enjoyment of supporting the protest march while claiming to be sick. The court said that the probabilities were overwhelming that the employee was not sick and in fact he was absent in order to avail himself for this protest. If he was able to clap hands and sing, it must follow that he would have been able to perform his contractual duties. Because an employment relationship is based on trust, SARS expects its employees to be truthful and honest. The court said that in this particular case, the employee created a false impression that he was too ill to come to work, and the fact that he was seen at the protest march is sufficient evidence to expose his false impression. The court accordingly held that the dismissal of the employee was fair. So in conclusion, ladies and gentlemen, What we have learned from this judgment is that when employees say they are sick, they must be sick. And if an employer obtains evidence indicating that the employee was not sick, disciplinary action can be taken, including dismissal. The case also highlights again that the trust relationship between an employee and the employer is very important, and if the conduct of an employee has resulted in a breach of this relationship, dismissal may be appropriate. So that then brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. If you have any questions or comments, we would love to hear from you. You can find us on social media or email us at info@masconsulting.co.za. Also, if you are interested in staying up to date with the latest news and insights on employment law, be sure to subscribe to our YouTube channel. I will see you next time. Bye-bye.